Welcome back to Toronto Speaks Legal Advice. Tonight we're answering your questions on family law, everything from marriage contracts to divorce and child support. My guest is Andrew Feldstein, family lawyer and managing partner at the Feldstein Family Law Group. Thank you so much for coming back on again. You didn't run away, we didn't scare you yet with any questions. You know, one thing that is really confusing, I think, about the whole spousal support scenario is when does it stop? When does it start? Who owes money to who, and so on. One question you always hear about, and you mentioned this, is, well, if my spouse moves in with somebody else, I get to stop paying spousal support. Is that correct?
No, it's not, and that
Why?
shocks many people.
Why?
When I started practicing 20 years ago, every agreement said you live with somebody, spousal support ends. Then the case law has evolved, some would say for the worse, not the better, and it's evolved to the point where if someone moves in with another person and they're receiving spousal support, all that's considered is a material change in circumstance. So if I'm the payor of spousal support and my spouse moves in with someone who doesn't make much money, so you take the scenario, I'm 50 years old, my spouse is 45 years old, and they move in with and they have a 25-year-old move in with them who doesn't make much money.
Oh, man.
I'm still going to be paying spousal support, and it'll have zero impact.
That's so surprising. And someone, Andrew's already on the phone waiting to get some more advice and shocking us with what the truth of the legal system. Peter, go ahead.
I was married for 4 years, and then I lived with a lady for 2 years, common law, and I had a house. I sold my house, and I moved with her. And I put all my money in her name and my name. Her house, it was in her name. And then I can understand what is it, 50-50 or whatever. I don't understand. Some words they say 50-50, and some words they say different. I don't get it.
All right, I think I need to clarify the question a little bit. Peter, is it that you divorced from your first wife?
Yes.
Okay, and then you settled that, and then now you're in with the common law. Are you asking if in the common law scenario, if the home has to be dealt 50-50?
Yes.
Okay, great. That's a great question. Go ahead.
Well, first of all, are you joint owners on title?
No, I'm not the owner. It's in her name.
It's in her name alone. And
Yes.
how long were you living together?
4.5 years plus 2 years as a common law.
Okay. What's the total period of time that you were living together with this lady? Are you saying it was 6.5 years or 4.5?
Yes.
Okay. And you put money into the house, but it's only in her name?
And her name, my money from my home, it went to her name and my name.
Okay. And then that money went into the house?
Yes.
Okay.
We
Well,
fixed all the house, and I pay her mortgage. She had a $70,000 mortgage.
okay. So here's the challenge. If you were married, it's very clear that equalization of net family property would apply under the Family Law Act. But when you are not married, you are not entitled to equalization of net family property. However, what you are entitled to make a claim for is a beneficial interest over the home, or arguably over all of the assets in the regime. And part of the test is that you're being unjustly deprived of your assets, and you would make a claim for a beneficial interest, as I said. Whether that claim for a beneficial interest would give you 50% of the home, 40% of the home, 25% of the home, isn't necessarily clear. There is a Supreme Court of Canada decision about 1.5 to 2 years ago that called it a joint family venture, and it lays out a rather complicated test that you have to go through. So no lawyer can sit there and say to you, you're going to get 50 cents on the dollar. It becomes, practically speaking, a judgment call and a negotiation process where your best day would be doing similar to an equalization payment if you were married and moving backwards from that. And you may very well have to litigate with her.
So, Peter, does that answer your question?
Yes, that means it's a 50-50.
I think that the answer is that 50-50 would only apply if you're married and divorcing, because that's the split that you have legally entitled to underneath the Family Law Act.
You may get to 50-50
Right.
through a beneficial interest claim, but really focus on the word may. It's, if you're married, you get what you called your 50-50, subject to certain exceptions, but when you're common law, you have to make a much more complex claim, and on your best day, you would probably get to 50-50.
But that's not legally, it's not in the statute, it's just common law and may or may not happen. So it's a different sort of legal case, and as you said, it's more of a negotiation.
Well, if you go to court, it's more complex. There's more arguments. It's more expensive. And both of you should really hope that you can negotiate a resolution and avoid the costly expense of going to court.
Would you suggest that a solution for Peter, or negotiate, put into a contract?
Well, first step in any case, unless you have something that's an emergency, is to try and negotiate a resolution. But if you can't negotiate a resolution, then you should go to court. You do need to consult with a lawyer. I always recommend to people that you are much better off going to a lawyer that either practices family law exclusively or does a lot of family law, rather than going to someone who dabbles in family law.
Peter, thank you so much.
Thank you very much. Thank you. I appreciate it.
Best of luck.
That was very nice of you. Thanks.
Thank you, Peter. Thank you for your call. And of course, I encourage all our viewers to call, and hopefully we can help you today as well. In fact,